Therefore, the death penalty should be used by a case-by-case basis, considering all the facts, not just one. Also, the fact... Yeah.
You're speaking a lot about age.
Yeah.
Reference number 18 and its arbitrary nature.
Mm-hmm.
Now, speaking in terms of contemporary community standards, even if the number 18 was arbitrary at one point, say the 1960s or 70s, when 18-year-olds finally got the right to vote and they were looked upon by the entire country as legal adults. In 2010, can we still say at this point that 18 is an arbitrary number, or has it been ingrained with our society?
Oh, I still think in this specific instance, 18 is still very arbitrary of a number, because this isn't voting. This is a matter of sentencing life or death. And as you said, on my birthday, July 9th. On July 8th, I can't get the death penalty, but on July 9th, I can. That's extremely arbitrary and capricious. Yes.
Excuse me, Kevin Stanford is one of the 4 black minorities that have been convicted of killing Caucasians, and he's just one of many statistics that show that 4 minorities are more likely to be convicted of the juvenile death penalty. Does this show how fair the death penalty is when the discrepancy between minorities and Caucasians is so high?
Well, what we're saying is that Kevin's background should have been brought up in his sentencing trial, and therefore the other side should be, it's not the death penalty's fault. This really shouldn't be an argument about the juvenile death penalty. This should be an argument about his mistrial, how his background wasn't brought up. Yes.
So clearly we see that regardless of Kevin Stanford, if someone else had been in his position and they did bring up his background, and like these factors are considered, then the death penalty should be perfectly constitutional, because all those factors, like the background, it's not an excuse. It's already been considered,
yes,
like in the trial, right?
It's already been considered in the trial, and it's very rarely used, so obviously it's not being abused. I'm just going to pass up to my co-counsel.
Also, following up with the regards of the constitutionality of the whole issue, cruel is defined as excessively inhuman with the intention of inflicting pain. So essentially, lethal injection would not be constituted as cruel under this definition, because it doesn't have the intention of causing excessive pain. Unusual is defined as arbitrary nature of application to the weight of the crime, not essentially to the crime in general. So you have an example: 10 people are caught for jaywalking, 9 out of 10 receive a $5 fine, while 1 receives a $5,000 fine. That essentially would be considered unusual in that circumstance because it's not proportional to the crime, as decided in Gregg v. Georgia. Also, in regards to the 8th Amendment, currently it is being interpreted as very broad. In the last ruling, Harmelin v. Michigan, which is the case about Harmelin was in possession of 672 grams of cocaine, and he received life in parole as his punishment. Now, he argued that his 8th Amendment rights to not being subject to cruel and unusual punishment was violated. However, Justice Kennedy ruled, where they upheld the decision, the 8th Amendment, and I quote, does not require strict proportionality between crime and sentence, but rather forbids only extreme sentences that are grossly disproportionate to the crime. So essentially, the 8th Amendment should serve as a check towards extremely disproportionate punishments rather than act as a guideline for sentencing in itself. Yes.
Many would argue that the death penalties, death is a final act. There's no redemption after it. Many people would argue that that is a cruel punishment for someone so young. So as someone who is speaking on behalf of the juvenile death penalty, would you say that the proportionality of the crime to the punishment is more important than the possible of this final act? Or should we take more into consideration the pure definition of cruel, saying that the cruelty of death is more important?
Well, the proportionality should definitely be taken into consideration along with the other considerations of age, and in regards to what Greg had asked Mr. Kleffner. The American Medical Association actually recognizes that the state recognizes that the legal age of majority, which is 18, is arbitrary, and that there are minors who are competent and others of legal age who are not. So essentially it should be done through a psychotic analysis of each individual so you can truly determine what mental age the person is at, because the physical age should not be a deciding factor.
So a few moments ago, you just discussed how the strict proportionality should not be considered as much as the extremity of the punishment. So aren't you telling me now that the proportionality doctrine...
The proportionality should be considered more than I said that it should be considered rather than extremely disproportionate. Like it should be used to keep in check the proportionality. Like for something extremely disproportionate, that's what it should be used for. It should not be used in regards saying, oh, we should punish someone based off of this. It should be used after the matter.
Many would argue that under the evolving standards of decency that the juvenile death penalty is one of these extreme disproportionate cases of punishment. How would you respond?
Well, that actually brings me to my next point, since it is in fact a state power right now, which is the state decides whether a juvenile death penalty is instituted or not. The states have an expertise evaluation on their specific society's standard of decency. For example, each state's laws differ in regards to driving age, marriage age, medical decisions age. All of these are changed and they vary from ages 14 to 18, and essentially that is why the state should have the choice to institute the death penalty or not, because there is no national consensus for the standard of decency. The ABA states that 30% agree with the juvenile death penalty, while I have a statistic proving from the University of Albany that 59% agree that juveniles should be sentenced and treated the same way as adults in terms of committing violent crimes. So through this inconsistency, you can tell that a national consensus over this is really inconsistent and in fact would make the decision arbitrary in regards to national legislation.
So just to clarify, you're saying that because the states have a better understanding of their constituency than, say, the national government would have over the entire national opinion, that we should leave the decision of whether or not a state decides to execute juveniles up to that individual state?
Absolutely, because they have the best consensus over whether, what their respective society is in favor of and what they choose in following. I mean, even the statistics that show it's so rarely used, clearly it's not being used as a matter of abuse.
Now, in the Supreme Court case Graham v. Florida, they ruled that life without parole is considered cruel and unusual for juveniles. Now, even life without parole, they have a chance for rehabilitation even though they're not allowed back into society. How do we consider that as cruel and unusual, and we don't consider the death penalty, the finality of it, as cruel and unusual?
Well, essentially, one could argue that by rehabilitating someone without letting them out, it's sort of dangling a string they could never really obtain in front of them, and that essentially would be unfair, locking them up in prison and leaving them there for life rather than just ending it. Why rehabilitate someone if you don't plan on using it?
Several times in the course of today's debate, you and your co-counselors have said that the rarity of the juvenile death penalty's use implies that it is not being abused. How exactly does the rarity of the punishment's use imply that it's not being abused? I would argue that if one juvenile is executed that is actually innocent, that the juvenile death penalty is a failure and has been abused.
Well, one can also argue with the rarity that it is in fact strictly applied. There are many different situations through which they go through. There are appeals, mandatory appeals, everyone reviews each case and the mitigating factors, including what we should consider as the age adds to that rarity, and that's why it is imposed so rarely, especially why it's outlawed in multiple states. So that essentially would be the issue. And also regarding retribution and deterrence, by removing the death penalty, ultimately, it's unfair to society. Bringing up the case that Justice Dow had brought up about two juvenile murderers who they shot 4 young women and a teacher in an Arkansas school. And because of their age, they were sentenced, they could only be held until they're 18. So essentially it's a year and a half for each murder they committed, while adults can be sentenced to life or even death. How is that fair, serving a year and a half for each death rather than a life for one?
I'm going to start off with my argument first. Central to this case is the 8th Amendment, something that is not brought up by the petitioners, which protects individuals against cruel and unusual punishments. The cruel and unusual clause is highly ambiguous and can be left up to much interpretation. Therefore, this court, in previous court decisions, eliminated ambiguity by clarifying cruel and unusual punishment. In Ford v. Wainwright, the court ruled that a punishment violates the 8th Amendment if it constitutes one of those, quote, those modes or acts of punishment considered cruel and unusual at the time that the Bill of Rights was adopted, end quote. Juvenile death penalty was a well-received and perfectly acceptable form of punishment in the 1780s, so juvenile death penalty does not violate the 8th Amendment in that regard. In Trope v. Doles, the court ruled that a particular punishment violates the 8th Amendment if it is contrary to the, quote, evolving standards of decency that mark the progress of a maturing society, end quote. In determining whether a punishment violates evolving standards of decency, the court must look not to its own subjective conceptions, but rather to the conceptions of the modern American society as reflected by objective evidence. In other words, a clear national consensus must exist in order to find certain punishments cruel and unusual. The best established barometers for proof of a national consensus are the state and local laws. The petitioners claim that the rare imposition of the juvenile death penalty, 22 executions in the past 37 years, proves that there is an overwhelming consensus against